Tell them why, too. Are there any other votes? Yes, sir. Announce the results.
Ayes 119, noes 0.
The bill is passed.
Assembly 9411, Calendar 448. Ms. Nolan, an act to amend the education law.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Mr. Kearns to explain his vote. Gentlemen.
Thank you, Mr. Speaker. It was an honor yesterday to have. Thank you, Mr. Speaker. It was an honor yesterday to have. Okay.
A little loud, Sergeant Yvonne.
Thank you, Mr. Speaker. It was an honor yesterday to have South Park High School in here, who was classified as a state as a school that would be going into receivership. Many of those students have done quite well, and although I am going to vote for this bill today, I think it's important that we look at, even if we're changing the definition of what a school is struggling or persistently struggling, I think we really need to look at the receivership law and the accountability standards that have been brought by the State Education Commissioner. Many of our schools in the city of Buffalo have many issues such as poverty, ELA standards, and other issues that are impacting what's going on. This school took a dramatic hit when it was put on this list, even after dramatic increases in their graduation rates. One day they were struggling, the next day they were out of that persistently struggling. The other issue I have with this definition is that a receivership can at some point in time go into an individual, and the lack of input from school boards. So although I'll be supporting the bill today, I do think that we need to make some changes and look at this and really have a hard look of how receivership will impact our communities. Thank you, Mr. Speaker.
Mr. Kearns in the affirmative. Are there any other votes? Announce the results.
Ayes 100, noes 4.
The bill is passed. Mr. Morelli.
Yes, sir. Thank you for allowing a brief interruption for a special introduction. On behalf of Mr. Dillon, we have a group of residents from Cypress Hills, part of the Cypress Hills Local Development Corporation, and they're here to observe our proceedings. I know they do great work back in Brooklyn, and they're here to watch the legislative proceedings, and we're delighted to have them. If you could please extend on behalf of Mr. Dillon the cordiality of the House to this outstanding group. I believe they're above you in the gallery. There they are, and watching us as we do our work, sir.
Certainly, on behalf of Mr. Dillon, the Speaker, and all the members, we welcome you here to the New York State Assembly. We extend to you the privileges of the floor. Hope that you have had a great trip here to Albany and are enjoying the proceedings. Please always be welcome. Always come back and visit us. Thank you. Ms. Corwin.
Thank you, Mr. Speaker, for allowing me to interrupt the proceedings as well. Our colleague, Assemblymember Finch, has some very special guests here in the chamber. Pastor George and Deborah Birkinshaw of the Calvary Bible Baptist Church out of Elbridge, New York. The pastor and his wife, Deborah, are newly married, so it's a very special time for them. And as it happens, they also happen to be the pastor for Assemblymember Barkley. And it was described to me that this is Assemblymember Barkley's confessor. So as you can imagine, it must be a very challenging position for sure for our pastor. So if you could please extend the cordialities of the House to these terrific people from Elbridge.
Certainly, on behalf of Assemblymember Finch and Barkley, we welcome you here, Pastor, and your wife to the New York State Assembly, and having two such distinguished Assembly members in your flock, so we say, you have a lot of work cut out for you. Thank you so very much. We are always pleased to have you, and obviously your members are excited that you have joined them today. Mr. Morelli.
Yes, thank you, Mr. Speaker. I'd like to now go to page 4 of the main calendar and take up Rules Report number 4 on debate.
Clerk will read.
Assembly 9535, Rules Report Number 4. Mr. Hasty, an act to amend the legislative law.
An explanation is requested. Mr. Morelli.
Yes, thank you, Mr. Speaker. Colleagues, today we are taking up legislation to address ethics reforms and begin our work to restore New Yorkers' faith in our government. I don't think it's a stretch to say, Mr. Speaker, and I hope everyone in this chamber would agree, that the vast majority of people elected to this chamber and come to Albany do so for the right reasons. But we can not turn away from the fact that there have been ethical issues that have cast a pall over our government. These issues diminish us all, and as a legislature, we have a responsibility to address this head-on and give the people of this state the confidence that we have the highest ethical standards. Last year, we took significant steps to strengthen ethics compliance. Today, we will put forward a proposal that will increase transparency and accountability and help restore the public's trust in our government. In summary, our proposal will limit outside income and prohibit a legislator from leveraging his or her public office for financial gain, prohibit payments for referrals when no services are rendered by the individual, close the LLC loophole, regulate housekeeping accounts by political parties, and enhance transparency in lobbying funds so that so-called dark money is exposed. And if I might, Mr. Speaker, I'd like to take just a few minutes to describe in a little more detail some of the provisions of this bill. First, as it relates to limiting outside income and enacting restrictions, the bill would eliminate the opportunity for a legislator to leverage his or her public office for financial gain. We define outside income for purpose of this bill as compensation for services actually rendered, and limit the amount of compensation that a legislator may earn in outside income to 40% of the annual salary of members of the New York State Supreme Court. This closely follows the model used by Congress. Under this scenario, no sitting legislator would earn more in active outside income than their current base salary. Fundamentally, the concept in this proposal is that you make what you earn through your activities and your work product. Legislators would be prohibited from receiving any payments for the use of his or her name in promotional materials such as letterhead or websites unless the legislator performs work for that firm. Also, if a firm uses a legislator's name in its promotional materials, any compensation earned by that legislator must be reasonable and proportionate to the work performed. The proposal also spells out rules for attorneys regarding referral fees and the splitting of fees. Legislators would not be able to collect any payment for simply recommending an attorney or obtaining employment by a client, and any referral fees or splitting of legal fees must be proportionate to the services performed by each lawyer. This essentially codifies the existing attorney rules of professional conduct established by the Appellate Division. As it relates to the LLC loophole, we're also taking steps to clean up elections and make campaigns more transparent. The bill closes the limited liability company loophole and regulates the handling of housekeeping money by political party committees. And the bill closes the loophole in two ways. First, it drastically lowers the contribution limits for LLCs to the same $5,000 aggregate limit applied to corporations. And it attributes an LLC's contributions to the true owners for the first time. As a result, individuals, wealthy or otherwise, will no longer be able free to flout contribution limits through the use of this loophole. As it relates to housekeeping accounts, to promote the proper use of and prevent the commingling of hard money that is used to support or oppose candidates, housekeeping money within party committees will be required to have segregated accounts and will be required for each to be segregated housekeeping and political party and campaign money. In addition, the proper use of housekeeping money would be to further clarify to promote transparency and accountability. As it relates to dark money and communications with newspapers and editorial boards, recently the Joint Commission on Public Ethics released an advisory opinion which defines certain communications with the press as lobbying activity, including the encouragement of an editorial board to support a position on a specific government action. This bill would clarify that communications with the press do not constitute lobbying activity and are protected under the First Amendment. Finally, we are taking steps today to limit the ability of special interests to influence government without disclosing the sources of their funding, referred to commonly as dark money. Currently, entities that lobby for themselves or hire a lobbyist are required to report the funding source of any amount over $5,000 if they have spent more than $50,000 on lobbying in a year and at least 3% of their total expenditures were devoted to lobbying in New York State. Charitable nonprofits are exempt from these provisions because they are barred from lobbying by statute. 501c4s, non-charitable nonprofits under current law, can ask for an exemption of disclosure of donors when there is a threat to safety. This bill lowers the threshold to $5,000 for lobbying activities and triggers the requirement to disclose any donors over 3% and eliminates the 3%, donors over $1,000 and eliminates the 3% threshold. Basically, this bill provides that all lobbyists and clients of lobbyists will be subject to the same donor disclosure requirement under the law. This bill comes to us after long discussion on the merits of trying to address many of the loopholes and challenges that we found in the past. I think it is a very, very positive step in the right direction. I would encourage all of our colleagues to support this and am happy for any opportunity to answer any questions.
Mr. McKevitt.
Sure. Will the majority leader yield for a few questions,
Will
please?
you yield?
Yes, certainly.
Sponsor yields.
There's a lot involved in this bill. I'm just going to go and touch on a couple of topics which you mentioned in the introduction. The first I'm going to begin with are the limit of income amounts. You had stated beforehand that the restriction in this would be similar to those of members of Congress. I note that the governor had a proposal which would have limited the outside income to 15% of the base income of $79,500. This bill reflects a 40% limit on the amount of a New York State Supreme Court justice, which this current year will be approximately $193,000. That will go up to $203,000 by 2018. So that varies between $77,000 and $81,000 of outside income. I'd just like to know, where did these numbers become derived from?
Well, as you can imagine, Mr. McKevitt, some of this is arbitrary as you're finding limits and you're finding metrics to use. Right. I do note that the way, although it's been described that the model that's in the proposed budget mirrors the congressional model, in fact, that's not true. The congressional model is a percentage of, as I understand it, deputy secretaries and members of the cabinet. So it's actually not a percentage of the congressional salary itself, which is the model that's been proposed under the budget that the governor has submitted. So we looked at it. We identified in the base year that while there would be outside income, it would be limited. We used an independent variable, which is the compensation by members of the New York State Supreme Court. And I just note parenthetically that a member of Congress, given the base salary that they have as a member and the outside income limitations, could earn well over $200,000 in a given year. Members of the legislature, under our proposal, would be limited to $156,000, with the majority of their income coming from their public responsibilities here.